This is Barry Zalma on insurance. I am an attorney retired from the practice of law and now spend my time as an insurance claims consultant and expert witness, an author and producer of these videos. Today I'd like to talk about what happens when an insurance company retains defense counsel to protect its insured, only to find that defense counsel provides an incompetent defense. Judging by my contact with defense counsel seeking expert witnesses, there appears to be a growing trend in the United States where insurers are willing to file malpractice suits against counsel they retained to defend their insureds. When an insurer retains a defense lawyer to represent its insured, only to find that lawyer is incompetent or committed malpractice in providing the defense, rather than admit the error in choosing a poor lawyer for the insured, the insurer sues the lawyer for malpractice, seeking reimbursement for the amount paid to indemnify the insured. Where the insurer retained defense counsel and where there was no reservation of rights, courts have allowed the primary insurer to bring a cause of action against the attorney for malpractice, finding that the attorney represents the insurer along with the insured, where at least they have common interests. Insurance defense counsel must manage their potential exposure to suits brought against them by insurers who ask them to defend insureds. This should cause defense counsel to reevaluate the limits of their malpractice insurance policies and to understand all the potential parties who may bring a malpractice claim against them. Likewise, insurers should recognize their own exposure with respect to claims of vicarious liability. They must also select defense counsel with the utmost care and diligence, because they may not be able to sue their chosen defense counsel if a mistake occurs. Insurers also need to make sure that the attorneys who represent their interests make appropriate disclosures to the insured's independent counsel. In a case where Great American Insurance Company attempted to sue its defense counsel for providing an incompetent defense to one of its insureds, a case called Great American versus Dover-Dixon Home, an Eighth Circuit decision of 2006, the Eighth Circuit Court of Appeal brought relief to the insurance defense bar when it refused to allow the insurer to successfully sue counsel retained to defend the insured for legal malpractice. The Eighth Circuit, considering the law of Arkansas, only allows malpractice actions to be filed against those with whom the parties are in privity. The Eighth Circuit dismissed the insurer's argument that it was equitably subrogated to the rights of its insured and concluded, quote, "Given that the public policy of Arkansas is to shield attorneys from malpractice suits brought by parties lacking privity with them, that the insurance companies lack privity with the defendants, and the appellants do not qualify for one of the two exceptions to the privity requirement, we conclude that the district court did not err by awarding summary judgment to the defendants," close quote. Some courts have allowed an excess insurer to sue because these carriers are only asserting the insured's right to bring a malpractice claim. This does not expand defense counsel's obligation beyond what they already are. An excess insurer is subrogated to the insured's rights against a primary insurer for breach of the primary insurer's good faith duty to settle. Consider Peter versus Travelers, a 1974 decision of the Central District of California. When there is no excess insurer, the insured becomes his own excess insurer, and his single primary insurer owes him a duty of good faith in protecting him from an excess judgment and personal liability. If the insured purchases excess coverage, he in effect substitutes an excess insurer for himself. It follows that the excess insurer should assume the rights as well as the obligations of the insured in such a position. In a case called Britton versus Seal, the Fifth Circuit concluded that a malpractice action cannot be assigned. It prohibited any action by anyone not in privity to file suit for malpractice. Another Texas court specifically found that in Texas, the law is well settled that no attorney-client relationship exists between an insurance carrier and the attorney it hires to defend one of the carrier's insureds. Absent the requisite attorney-client relationship and the absence of any other alleged relationship, the insurer lacks standing to claim breach of fiduciary duty. Accordingly, the trial court did not err in granting summary judgment in favor of the law firm. Some courts have equated a subrogation action with the assignment of a legal malpractice claim. Many state courts have rejected the ability to assign a malpractice claim on the basis that it undermines the sanctity of the attorney-client relationship. Other courts have found no right whatsoever of an excess carrier to bring suit against the attorney hired by the primary insurer on an equitable subrogation basis. These courts have relied upon the fact that an attorney's duty of loyalty is so overwhelmingly for the benefit of the insured that any liability of the attorney to an excess insurer forces the attorney to look over his shoulder and worry about how the excess insurer is going to view what is being done. The Louisiana Supreme Court has recognized that an excess insurer, on the other hand, may become subrogated to an insured's rights against its primary insurer to assert bad faith failure to settle a claim, which ultimately results in the excess insurers making a payment on behalf of the insured. A U.S. District Court in Virginia ruled that an insurer could sue a law firm for legal malpractice as a non-client beneficiary of legal services. The court noted that despite sharp doctrinal differences regarding the relationship between the insurer and the firm it retains, nearly all jurisdictions in the United States permit some form of legal malpractice action by an insurer against the firm it retains to defend an insured. The district court concluded that permitting an insurer to sue the firm it retains allows the insurer to, quote, promote enforcement of the firm's obligations to the insured, despite the fact that the tripartite relationship between insured, insurer, and defense counsel contains rife possibility of conflict. Nearly all courts have concluded that the harms-benefit calculus weighs in favor of recognizing an insurer's legal malpractice claim against the lawyer or law firm it retains to represent an insured. For example, in Century Select versus Maybach Law Firm, a 2018 decision of South Carolina Supreme Court, Century Select Insurance Company brought a legal malpractice lawsuit in federal district court against the lawyer it hired to defend its insured in an automobile accident case. The trial court, unable to find precedent in the state, asked the Supreme Court two questions. One, whether an insurer may maintain a direct malpractice action against counsel hired to represent its insured where the insurance company has a duty to defend, and 2, whether a legal malpractice claim may be assigned to a third party who is responsible for payment of legal fees and any judgment incurred as a result of the litigation in which the alleged malpractice occurred. Century Select hired Roy P. Maybank of the Maybank Law Firm to defend a trucking company that Century Select insured in a personal injury lawsuit in state court. Maybank failed to timely answer requests to admit served by the plaintiff, and 7 months later filed a motion seeking additional time to answer the request, which the circuit court held under advisement until the parties completed mediation. Century Select claimed that because Maybank's failure to timely answer the requests and the likelihood the circuit court would deem them admitted, it settled the case for $900,000, when Maybank had previously represented to Century Select it could settle in a range of $75,000 to $125,000. When an insurer hires an attorney to represent its insured, an attorney-client relationship arises between the attorney and the insured, his client. Pursuant to that relationship, the attorney owes the client, not the insurer, a fiduciary duty. An insurance company that hires an attorney to represent its insured is in a unique position in relationship to the resulting attorney-client relationship. Pursuant to the insurance contract, the insurer has a duty to defend its insured and must compensate the attorney for his time in defense of his client. If the insured settles or the judgment imposed against him, the insurance contract ordinarily requires the insurer to pay the settlement or judgment. Because of the insurance company's unique position, the answer to question 1 is yes. An insurer may bring a direct malpractice action against counsel hired to represent its insured. The insurer may recover only for the attorney's breach of his duty to his client when the insurer proves the breach is the proximate cause of damages to the insurer. If the interests of the client are the slightest bit inconsistent with the insurer's interest, there can be no liability of the attorney to the insurer. The attorney's duty to the client may never be affected by the interests of the insurance company. As a final limitation on an insurer's right to bring an action against the lawyer it hires to represent its insured, the insurer must prove its case by clear and convincing evidence. In this case, there appears to be no risk that the decision will place the attorney in a conflict position or create any divided loyalty. The attorney's duty to his client includes the obligation to timely respond to requests to admit. The fact that an insurance company may suffer financial loss from an attorney's negligence in failing to timely respond to the requests, and the court's recognition that the insurer may sue the attorney to recover this loss after settling the underlying case to protect the interests of the insured, do not in any way affect the attorney's duty to his client. I have personally, since 1972, defended insureds at the requests of their insurers. I lost insurance company clients by rendering advice contrary to the insurer's interest that was necessary to protect the client they hired me to defend. Although an insurer can sue the lawyer it hired to represent its insured for malpractice, it cannot sue its lawyer for giving good legal advice that might cost the insurer more money than it wished to pay. Few lawyers will be willing to take on cases from an insurer, however, who makes it a practice to sue its lawyers it hires to defend its insureds for malpractice. If the lawyer commits malpractice, he or she is probably not appropriate to be hired to defend its insureds and should never be hired again. For the most part, courts have declined to acknowledge a direct client relationship between an excess insurer and defense counsel. As a result, some states have ruled that excess counsel have no right of action at all. Indeed, in many state courts have refused to acknowledge a client relationship between defense counsel and the primary insurer. So before making a decision to sue a lawyer who was hired by an insurance company for malpractice, the insurance company must contact and seek the advice of experienced coverage lawyer in the location where the suit would be contemplated to be filed, because different states deal differently with this type of lawsuit, and it would be contumacious conduct to file a suit in a state that would not even consider, because of a lack of what it considers privity or a lack of standing, and would just dismiss the lawsuit out of hand. This video was adapted from my book, Zalma on Insurance Claims, Part 108, Second Edition, which is one part of a 10-volume work called Zalma on Insurance Claims, and is available from Amazon.com as both a Kindle book and a paperback. If you found this video to be of interest or useful, please forward it to your colleagues. It's free. And please subscribe to my YouTube channel, my Rumble channel, and my blog so that you can be advised of future videos and blog postings. Thank you for your attention.